family law, there can be a question on solemnization of marriage under the Special Marriage Act. So, when a marriage is intended to be solemnized under the Act, the parties to the marriage, number one, shall give notice thereof in writing in the form specified in the second schedule of the to the marriage officer or the district in which at least one of the parties of the marriage has resided for a period of not less than 30 days. Now, what is the nullity of marriage under the Special Marriage Act? According to Section 24 of the Special Marriage Act 1954, on the petition of either of the party, a marriage can be declared null and void by the decree of nullity. Now, following are the grounds either party as a living spouse. Very, very important this is. What is nullity of marriage? Now, nullity of marriage in India, the law, rules and regulations we'll see in detail. So, very, very important topic for exam it is nullity of marriage. Nullity in general means an act that is legally void in nature. In case of a marriage, it means a legal statement by the family court that there was the marriage didn't exist. This marriage didn't exist between the two people and marriage was not valid. The declaration makes it clear that the marriage never took place. So, difference between nullity of marriage, divorce and judicial separation. Though nullity, divorce and judicial separation are the ways to end a marriage, but they are not similar. There are differences between these three. Nullity of marriage. As mentioned earlier, the nullity of marriage is a legal declaration that the marriage was not in existence. It was not in existence. It points out that the validity of marriage, according to law, it was performed. It was the validity of the marriage, yes. It was performed. This means that there was not a valid marriage has been performed between the two parties. Either the parties or the circumstances is not valid by the law. In divorce, divorce is a formal ending of a marriage. It is a legal declaration on the petition by the parties of the marriage that led to the end of a valid marriage. Under a divorce, the validity of the marriage is not questioned, but it is a question the continuation of marriage. If successful, it ends a valid marriage. A divorce is more permanent than nullity. And yes, the judicial separation. Now we talk about what is judicial separation. Very important point for your exam is judicial separation is declared legally on request of the parties that they must be allowed living separate under the status of marriage. It is not an end of a marriage, neither it questions the validity of the marriage under the judicial separation. Duties and liabilities remain the same for both the parties. So, very, very important topic for exam is differentiate between, we did just now, differentiate between nullity of marriage, differentiate between what is divorce and what is judicial separation. So, these are all petitions we file in the family court. Irretrievable breakdown of marriage. The divorce is the latest ground that the Supreme Court has given. So, nullity of marriage under the Special Marriage Act. Number one, either party as a living spouse, either party is incapable of giving valid consent due to unsound mind, and of course, mental illness or unfit to the procreation of children. Parties are under age. The parties are underage. Parties are in a relation of prohibited degree. Impotency of the respondent. Now, other grounds to declare voidable marriage, null and void under Special Marriage Act, due to the willful refusal of respondent, marriage not being consummated, pregnancy of the respondent by some other person at the time of marriage, consent of any of the party was gained by fraud or coercion as defined by the Indian Contract Act. Now, procedure to obtain divorce or obtain decree of nullity of marriage. Yes, the petition should be presented before the court, concerned court under different personal laws under the Hindu Marriage Act and the Special Marriage Act. 1954, the family court or the city civil court decides a matter. Under the Muslim law, the matter does not decide by the court, but the matter decided by the religious practice under the Parsi law. Court means the court established under the Parsi law. The jurisdiction of the concerned court will decide whether the defendant or the respondent, wherever the respondent or the defendant resides, the court issues a notice to the respondent or defendant to give a reply before the court. The court grants relief accordingly after hearing all the evidences. So, maintenance under nullity of marriage. Yes, acting upon the petition submitted, when the court declares nullity of marriage, it also decides the maintenance to be given to the opposite party, either in lump sum amount or yearly or monthly. Legitimacy of children born out of null marriage. According to Section 16 of the Indian Marriage Act, 1955 grants legitimacy for the children born out of void marriages. This particular section protects the children born out of void marriage and prevents them from being, helpless. So these are the things that is very important pertaining to